Thank you for watching. My name is Advocate Muhammad Abduroaf, and today's topic is the issue of a quick divorce. Many people approach me and they ask me, Advocate, what's the quickest way to get divorced in South Africa? And generally, my answer would be if you and the other party agrees upon the divorce, I can get you guys divorced within a month or two maximum. So it's possible. Any lawyer will tell you that because the parties are in agreement and we draft the documents, we issue the divorce papers, and we get a court date, and there it is. We get the parties divorced. But how simple is it? Is it really that easy to get divorced quickly if both parties, on the face of it, come to you and say, we want to get divorced? Now, the first challenge that me as a legal practitioner has is getting the parties to agree upon all the terms of the divorce, especially so if there are minor children involved. They come into me as an advocate, a professional, and once I assisted the parties at least to get divorced, there should be no comebacks. They shouldn't come to me a few months later and say, Advocate, oh, the pension fund never paid out because the divorce clauses aren't correctly drafted. Alternatively, they shouldn't come to me and say, Advocate, why has the court not granted the divorce? Because a family advocate objected to the terms of the settlement agreement. Or there might be other issues, for example, the division of the joint estate. There's a house involved, and I never dealt with those specific aspects in the settlement agreement, and so on. So the first point of call would be, can we agree upon all the terms of the divorce? The division of the joint estate, accrual if the parties are married out of common property with the inclusion of the accrual system, possibly selling of or termination of joint ownership of property if the parties are married out of common property without the accrual system, but they purchase immovable property together. Issue of child maintenance, child custody, the issue concerning guardianship rights of the parents. For example, if one parent travels a lot, can we have a clause in there that one parent's consent, only a single parent's consent is required for the minor child to travel overseas, or for consent for school excursions, the application of a passport, and so on. So these are the things that we have to deal with properly in a settlement agreement if the parties want to get divorced. But let's say for the purpose of this discussion, we resolve that issue really quickly. It's a simple matter. The parties have resolved the issue concerning the property, the kids, everything, and we drafted the document. So it's the 1st of March, for argument's sake. We sign the documentation, we draft the necessary court documentation. It will be a summons, a particulars of claim. The particulars of claim will basically say these are the parties, they were married on a certain date, these are the problems in the marriage, and the parties entered into a settlement agreement, and I annex the settlement agreement to the particulars of claim, and I ask for a decree of divorce incorporating the terms of the settlement agreement. Very easy. Then that specific summons will have to be served on the other party. So one of the parties must come to me and say, Advocate, I'll be the plaintiff in the specific scenario. Friendly divorce, no problem. Let's say in my scenario, the wife is my client and she's a plaintiff. That summons will have to be served on the defendant wherever he or she works. Wherever he works. It could be in Cape Town, it could be overseas. It doesn't really matter as long as one of the parties lives in the Cape Town area, with the jurisdiction of the court. It doesn't really matter. And that specific summons will have to be served upon the other party. If the other party resides overseas, then obviously the issue of illegal citation comes in. I'll have to serve the documentation on the other party via email or via an attorney that side, but I must first get the court's consent. So that could cause a bit of a delay. But let's not complicate it too much. Let's say both parties lives in Cape Town, and I have the sheriff serve the summons on the other party. Problem solved. Wonderful. Now, the other party, despite knowing, or the defendant, despite knowing that the divorce will be unopposed or a friendly divorce, where both parties agree upon the divorce, the other party should still get basically the 10 days as stipulated in the summons to decide to defend the divorce or not. Let's say the 10 days has passed and he decides not to oppose the divorce because we agreed upon those specific terms at my office when we discussed this whole matter. Then I can apply to court for a divorce date. Apologies. Let's say, for argument's sake, we get a divorce date, and the divorce date is 3 weeks from there because we are lucky and the divorce dates are quite available. I'll set the matter down for that specific date. And at the same time, if there's a settlement agreement and there are minor children involved and there might be a parenting plan, I will have those specific documentation endorsed by the Office of the Family Advocate. We come to court on the day, the matter's on the roll. I prepare my client the day before or the morning of the matter. The question I'll be asking him: Are you the Are you the plaintiff? Is that you were married to the defendant on a certain date? In Cape Town, wherever they got married. These are the problems in the marriage. She will advise you what they are. I will refer to the consent paper. Has it been signed by both parties? I refer to the signatures and so on. And that's it. And I'll also call for a decree of divorce incorporating the terms of the consent paper. That's in a nutshell how it works. So an unopposed divorce is quite simple if the parties can come to the point of having a proper drafted settlement agreement. If that is the case, great, the matter will proceed and it can be finalized very quickly. On the other hand, and I'll mention this, if the parties cannot come to an agreement, and let's say the wife comes to my office and say my husband won't agree upon anything, I can still draft the divorce summons. I could still potentially attach there to a settlement agreement, allowing the other party an opportunity to sign there too. Or I can have an alternative clause. I can say, oh, my client would like to have the following A, B, C, and D. Alternatively, the settlement agreement, if signed, should be made in order of court. These are all the possibilities. But if the husband in the scenario decides not to defend the divorce action, and the 10 days has lapsed, then the divorce will proceed, but based upon what my client has asked for in the divorce papers, in the summons. Because under these circumstances, there has not been any settlement agreement that has been signed. But the parties are at any time at liberty to enter into a settlement agreement before the divorce date. But remember, if there are minor children involved, that settlement agreement will have to first be taken to the Office of the Family Advocate to have a look at and to see whether or not it will be in the minor child's best interest and to endorse that specific settlement agreement. The court would want the Family Advocate to have a look at it, and that's a requirement in our law as well. So there we go. So getting a divorce in a period of 3 to 4 weeks is possible. It all depends on the clients, number one, and also the availability of the court role. During COVID, for argument's sake, the dates were a bit far apart because the court didn't deal with many divorce matters. But now that that's all over, the court might be more available to hear divorce matters and allocate more matters on the roll. Otherwise, all the best and thank you for watching.